All right, well, looks like we're at the top of the hour. I know it's been a long day, and thank you. I'm really grateful to have such a big group of folks here at 4 o'clock on Friday. I know that social outings are calling your name as we speak here, but I'll just dive right in. My name is Doug Edmunds. I'm the Assistant Dean for IT at the UNC School of Law back in Chapel Hill, North Carolina, where we, once upon a time, were known for more than all our scandals. Anyway, I'm here today to talk about law practice technology, pitching a course, teaching a course, learning from teaching that course, and hopefully share a little bit of information that will allow more and more of us as technologists and law librarians to do the same thing at their institutions. Before I even get into the Prezi and start talking, I want to do a little sort of social history primer on Mr. Susskind here. How many of you know Richard Susskind's name? Kind of like Casey Flaherty and some of these other folks that we've been hearing about. His name is very much well known in this sector at this point in time. He's been writing about the intersection of technology and law practice for a number of years. His latest book, Tomorrow's Lawyers, was one that we didn't actually assign to students. We did assign some readings from it, but we didn't make them get the book. But it's a really slim and easy to read volume. I highly recommend it for anybody that's in our role at law schools. And he talks about, in this book, the fact that there are 3 drivers of change affecting the legal industry. And the first being the more for less challenge. And he defines that as, in the complex world in which we live nowadays, there's an even greater and increasing need for legal services, but fewer providers or fewer people can take advantage of that based on price, basically. The second driver of change is the liberalization of legal services. And what he means by that is the fact that, and this is much more predominant in the UK and increasingly maybe places like Australia, but back in the UK in 2007 they passed what was known as the Legal Services Act. And the key provision of that allowed for what they called ABSs, or alternative business structures. And what this was non-lawyers being able to own and run legal businesses, kind of a revolutionary idea. And in addition to that, they could receive external investment from angel investors who are non-lawyers, and non-lawyers could actually be a partner in the firm. So this was a pretty revolutionary thing in the UK, and it's sort of changed the legal landscape over there. It's gotten to where you can walk into a Tesco, or which is like their version of Woolworths or a Walmart, and get basic legal services. So in America, compare that to the fact that now you can go into a Walmart and go to your bank, not just get your nails done or whatever else you're doing at the front of a Walmart there. But so imagine that happening in the United States. Kind of a big departure from what we're used to. And then the third driver of change that Susskind talks about is information technology. So he likes to talk, in Tomorrow's Lawyer, he spends a good deal of time talking about this evolution of legal services and how it's really changed from what he likes to call a bespoke model. I don't know how many Anglophiles are out there in the crowd. I love that word, bespoke. I'm going to Carnaby Street in my bespoke suit. Bespoke just means highly tailored, highly crafted in an individual way. And so he talks about this evolution over the last 10 or 20 years from a bespoke sort of approach to legal services to now one that is increasingly commoditized. That's his word. And he points out, interestingly for us, that law school often treats each case as if it were rather unique, involving fact patterns and challenging concepts worthy of the Supreme Court. And he calls this notion that legal work is bespoke in nature, quote, an unhelpful, if often romantic fiction. He goes on to argue that much less legal work requires such a tailored approach nowadays, and that most lawyers would choose to, than most lawyers would choose to admit. And most strikingly, he contends, quote, that deploying bespoke techniques in many instances is to adopt cottage industry methods when mass production and mass customization techniques are now available to support the delivery of less costly and yet better services. So he goes on to point out that this is not only true, or this is not an either-or proposition, really, this idea of having to offer either bespoke solutions, which are bound to be more profitable, versus the commoditized ones, which are going to be cheaper to the consumer and hence less profitable to the lawyers and law firms. So if this binary viewpoint is wrong or skewed at the very least, what does he offer as an alternative? Well, he begins in his book, Tomorrow's Lawyers, by talking about these 5 distinct stages in the evolution of legal services. And I would have written them on either side of the whiteboard, but I couldn't find one of those magic pens up here. So we start with bespoke, then it goes to standardized, systematized, packaged, and commoditized. So let's talk about that for a minute, because it was Suskind's arguments and his whole sort of framework that really got me inspired to teach a class, and which really made me feel, in addition to the new ABA Model Rule 1.1 Comment 8, that you have to have technological proficiency as a lawyer, it was these kinds of ways of thinking that really inspired me to teach it. So let me just pick this evolution apart really quickly. So he talks about how many legals are just no longer bespoke. More typically, he argues there's a degree of standardization that comes into play. This could be simply using a standard procedure manual or a checklist for, say, preparing a contract. Beyond that, clients would expect any attorney worth his weight in salt to not start every single contract from scratch, but rather work from some kind of a template. So that's the standardized approach. He then goes on to talk about how this evolutionary model would include systemization, and this is where technology, legal technology tools really come into play. And he just uses automated document assembly as a prime example of how technology can greatly reduce time and effort on the part of the attorney and thereby save the client money. We see examples of that with things like A to J Author and Hot Docs, document assembly engines. While these various options exist that put pressure on attorneys to compete in the marketplace, Suskind moves into what he calls packaged services, or bundled services, a lot of people refer to them as. And this is a real departure from the billable hour that we've known all these years, but it's an increasing reality for a lot of law practitioners. And what he means by packaged services is a series of tasks that a lawyer might normally perform individually or in collaboration with a partner, and bundling them together as a single offering with a predetermined price. He actually cites an example. One of his biggest consulting clients, the corporate tax division of Deloitte, actually did this. They packaged all their legal knowledge of many of their attorneys into a client-focused offering, put a single price tag on it at a much lower premium. So in doing so, he argues, they increased value for their customers, but forced themselves to re-engineer a lot of their work practices. And in a rather fundamental way, moving further and further away from this old hands-on bespoke model that had served them so well for so many years. And in doing so, that was a pretty brave move for such a big company. But that's the kind of progressive kind of thinking that he really touts as sort of the next wave in legal practice. So many lawyers do bristle at this sort of notion of selling their knowledge in neat little bundled packages. But Suskind's response to that is, quote, "Our focus should be on helping our clients to meet their formidable more for less challenge rather than obstinately holding on to outdated, inefficient working practices." Well, would that were the case. It's not that simple all the time in the real world to convince lawyers, let alone law professors, to change their tried and tested ways. So at the end of this evolutionary model, he gets into what he calls commoditized legal services, and those are the ones that are just so rote and commonplace that they can really, can be and should be offered to the consumers directly online at little to no cost. So that's just sort of the framework, the mental framework that got me thinking about the fact that the legal profession really is changing. And of course, our students need to come in and learn all the theory. They need to learn the practical skills of writing effectively. But at Carolina Law, at least, I asked around, talked to my faculty friends, and said, is there a need for an e-discovery class? Is there a need for any kind of technology practical course? And honestly, I got mixed signals. And so, and by the way, there is going to be a free prize to anybody who can identify the artist of each one of the tracks. Each one of my little tracks here, so starting with one way or another. Don't shout it out. Can't shout it out. I'll talk to you afterwards. You get first come, first serve here. All right. So one way or another, I was going to get this done. I was thinking, we really do need a class like this. So these were some of the challenges that I was faced with. And, the last speakers, Maureen and Justin, was it?
Jason.
Jason, I'm sorry. Maureen and Jason talked a little bit about some of these challenges. So, I was met with a bit of skepticism on the part of our faculty. Then there was the just in terms of some of the turf wars and things that people said about, there's competing electives. There's a lot of upper level classes that only get offered once every year, maybe even once every other year. And here I had the audacity as the assistant dean for IT, I'm not even a faculty member, to propose this course. Well, I collaborated with my colleague Steve Melamed from the Law Library. He's now the assistant director of the Law Library. He couldn't be here today. But he does have an adjunct appointment in the Law Library and had taught American law to our international students. So he already had sort of some skin in the game. And even with his collaboration being a part of this process, there was some administrative resistance because they said, well, Doug, you're an EPA non-faculty member. You don't really have a faculty appointment. We've never let one of the assistant deans teach a course. We're not so sure about that. And then there were just the financial constraints. I wasn't going to do it for free. They didn't want to pay me more. And just the logistics of a big public university to sort of work through those channels and say, well, if a person who's already got one role wants to do a little bit more and we've got to pay him a supplement, how does that work? These are just all things that I'm saying because you can tend to focus on all the, what are we going to teach, how are we going to do it, how are we going to grade it, and all that stuff, and I will get into that as well. But these are sort of the upfront hurdles that we had to think about before we even proposed the class. And I know in that last session, a lot of you were here, and some schools or some folks in the audience said, gosh, I didn't have any pushback. My faculty was enthusiastic. The administration just kind of rubber stamped it and said, I'd love to have you teach the class. But it was a little bit more difficult at Carolina Law. So with that in mind, here are some things that I did, or that Steve and I did, to kind of make it easier. And I always use this with any major IT projects that I've done over the years. It's always important, I think, to find a champion, or two, or three. If you can get a faculty member on your side, you're going to get a lot farther than if you're just the IT person or the law librarian going to the dean with an idea. And we don't have a lot of really technically savvy professors at Carolina. I hope I'm not hurting anybody's feelings who's out there listening to that, but I think most of our faculty would agree. But there are pockets. There's pockets of interest among our faculty, and some of the younger faculty we've hired in the last few years have been very enthusiastic about it. And so I definitely reached out to them early on and said, do you think this is a good idea? Do you think it would fly? And I got a lot of positive feedback from them, so that was one thing. Collaborating on the course outline. Props to our friend Ken Hirsch here and Wayne Miller, who began teaching a course similar to this at Duke Law years ago, long before I even got to the law school, I believe. And Steve Melamed, again, my colleague, said we should talk to Ken and Wayne, and they were kind enough to share their syllabus with us. When we were first formulating an idea of how we wanted to go about this, what topics we might cover. Of course, teaching technology or law practice technology nowadays is such a moving target that some of the stuff that they had on their syllabus had already changed and evolved, but it was very helpful early on to see an example of what somebody else had done. Engaging students, again, I think Maureen mentioned that she asked around for the students who had pre-enrolled, what do you want to learn? I didn't go that far because at this point it was just an idea in my head and we were writing the course proposal, or we were about to write it. But I did start, as the Dean of IT, I come into contact with a lot of students. We're very hands-on. I have a very small shop, so I still end up doing a lot of laptop support for students. We don't send them to main campus. We provide the same level of service to our students as we do to faculty and staff, and I've always sort of prided myself on that approach. So our students love the IT department, and I would ask around as I'd be helping students with their laptops or with ExamSoft, whatever it may be. If this were a course that got offered, would you take it? Would you tell your friends? And again, the feedback I was getting was largely positive, so it seeded the idea and sort of gave me the encouragement to move forward. And the other big thing, that last point, is just really about the process that may exist at your institution. Again, some people in the crowd at the last session said there really wasn't much of a process. I kind of floated the idea and it was well received. We had an academic affairs committee. All new course proposals had to fit a certain model. They had to be submitted. There were deadlines. They even had to be formatted a certain way and include certain parameters. So it was a pretty formal process. And we followed that process and submitted the course proposal back in, let's see, I think it was fall of 2011, and the Academic Affairs Committee met, considered the proposal, said, you're in. We like the idea. We want you to teach it. So Steve and I got all excited. We started really thinking about bringing in some outside vendors to talk about their platforms or products and having guest speakers and doing this and doing that. And the academic schedule came out for the following year. We weren't on it. I went to my dean for academic affairs and said, hey, what's up? I mean, the course got approved. Oh, well, yeah, there's a lot of competing electives and, other courses that we don't offer all the time. So you're not going to be on it next year, but we're definitely going to offer it. So the next year rolled around, and the academic schedule comes out in the spring. And I'm like, where are we going to be? Tuesday, Thursday, Monday, Wednesday, Friday? We're not on it. Again, so it took 3 years from the time that the course proposal got approved to when we could finally teach the class. And so that's a lesson in perseverance and stick-to-itiveness and just caring enough that keep fostering the idea, keep going back to the table, and sort of giving people that need to be given that nudge, reminding them, we did have this course that was approved a couple years ago. We really do still want to teach it. And so finally, in academic 14-15, the year that we just finished, the course got added, and it's a 2-credit class, upper level obviously. It meets twice a week for an hour, which even that just seemed like not enough time to get into all the topics that we had in our heads that we wanted to cover. And let's see what I got here next. Yeah, so then the real work began. So I thought, okay, I mean, we had done some of the legwork up front, obviously, when we did the course proposal. As part of that formal submission, you had to write sort of a brief outline, but then you had to do sort of a straw man syllabus. So we did have to develop, to some extent, a syllabus at that time, but we hadn't really dug in until they finally added it to the course calendar. And then we thought, all right, now we really got to get to work. So some of the things we had to think about, again, were, okay, well, time constraints. How much material can we realistically cover in a 2-credit class that's only going to meet twice a week? Can we do 2 weeks on e-discovery? Can we do a whole week on case management and try out a couple different products? It was really sort of a guessing game at that point because this was the first time we'd done it. So that was something we needed to keep in mind as we're building out the syllabus. Is it going to be a writing requirement class? All our upper level classes are designated as either WE or RWE. I don't know if all schools are like that, like a rigorous writing experience or just a writing experience. That determines whether students will have to write a paper, and the rigorous one has to be longer, obviously. So we started thinking, okay, what are our grading parameters going to be? What kind of assignments are we going to offer, and is it going to be a writing class or not? We ultimately did decide to make it a writing requirement and have the students write 12 to 15, 18-page paper at the end of the course, which I'll talk about a little bit more here. Hands-on labs, again, how much time can we carve out realistically for doing hands-on activities? I mean, one of the big appeals of offering this, I think, to students was they wanted to get their hands dirty. They wanted to see some of this stuff, play around with some of the software that they've been hearing so much about, get some real live experience. Just like the students who take clinical courses, for instance. Gary likes to name check me every time Clio comes up. I feel like a Clio shill at Cali every year now. But we were one of the early adopters in our clinical program. And it's really changed the way that the clinic operates. And the students used to grouse about using the former product, and I won't disparage their name. They're still out there. And I think they've gotten better. And frankly, there's still some schools that really swear by that product. But our students used to have a lot of problems and they couldn't access it, and we had a lot of Mac users even back then in 2010. And when we moved to Clio, it just sort of like changed the mood in the clinic, and students felt like, I'm touching something now, I'm doing something that I could see myself doing when I get into practice, and which I hear a lot more small firms and solos are using this kind of thing, cloud-based software, what's it all about? So, when we started building the course, I thought, well, what kinds of software can we have access to for free? We don't want to license it and have to pay for it if it's just for a learning experience. And how much time realistically on the syllabus are we going to be able to devote to that? And then are we going to be able to grade those sorts of activities? Or because this isn't a pass-fail class, I should have mentioned that. It actually is a 2-credit class, but it's not pass-fail. So we had to come up with a grading scale and rubric and so forth and so on. So these were all the questions that we started to really have to consider once we got into the syllabus writing. Again, we had a nice example from our friends down the road at Duke to kind of go off of, but they had, again, taught it a few years in the past. So I'm going to share with you now, and again, this is probably not going to be real visible to a lot of people at the back, but let me see if I can blow this up just a little bit. Whoops. So here's our page 1 of our syllabus, and you can see that it just kind of lays out all the course requirements and so forth. It'll include, ultimately we decided that the requirements would include a 20 to 30 minute class presentation, and we'd wait till the end of the semester to have students do that. And the presentation was going to be tied to these research papers that they were going to write. We left it pretty wide open. It was a technology topic of their choice, but the main gist of it we wanted to be something that's really affected the legal profession, and that hopefully touches on the ethics considerations and things like that. As it says, the project should substantively relate the technology to the practice of law. What's that?
I like that paragraph.
Well, we try to write like lawyers might write. I was an English major, so I'm a stickler for clear spokenness. Hopefully you'll think that at the end of this session. But in any case, so those are the course requirements. And then we have the testing and due date. So we were going to have this course project topic due early in the semester. So we start our semester January 7th, January 8th. So we wanted to set an early due date to get the students kind of on the hook. We wanted to make sure they had thought about a course topic and that they submitted a course project idea. We could then have plenty of time to turn around, give them some feedback on that, set them up for success, so that they weren't floundering later in the semester. That second assignment we actually modified. This is an original version of the syllabus, and after we posted it on Sakai, it became a work in progress, like syllabi often are. But that company research exercise originally was going to be go out and research some legal technology company that's having a big impact in the industry, and just write a 3-page summary or something like that. We ultimately decided we wanted to change the scope of that a little bit, and we had them do a document management system review. So it was sort of a critical review of document management solutions out there. There's any number of them, as you all know, but we thought you guys pick. You can pick the 3 biggest, most prominent ones in the market space, or pick some of the up-and-comers. It's your choice. So it was like a mini research project in a way, and we set it up sort of just for fun. We said, you're a junior associate at a law firm. All the partners have no knowledge of DMS. They don't know what it is or how it works. They just have a paper filing system. So your role is to go out and research all the software vendors that are offering this and make a recommendation to the senior partners of the law firm. So that's how we kind of spun it. And it was interesting to see how students interpreted that and how they actually wrote it. Some of them were very informal. Some of them wrote it as an internal memo to their imaginary associates at the law firm. But in any case, that was one of the graded assignments. February 18th due date, the outline of the course project. So again, this gets into these sort of iterative feedback and the rubrics that we keep hearing about. These, we don't just want to give a final grade and have the students sail through the semester not knowing how they're doing. We wanted to give them some iterative feedback along the way. And so in addition to the original course topic idea, which was just a paragraph or more, we had them sort of outline their idea, flesh it out a little bit more. We did have a lot of questions about this particular assignment because I don't know that we were overly clear. But basically Steve and I wanted them to, before spring break, we wanted them to have thought through the scope of their final project, break it down in an outline form, so where when they came back from spring break and everything was just craziness, the students get so busy that time of year, we wanted them to already have a pretty fully fleshed out final project. So that's what the outline there was all about. The presentation exercise, this is interesting, again, harking back to what Maureen and Jason were talking about as they thought about their course. We wanted them to get in front of us and do some sort of presentation, but the final project also included that element where, they're going to write their final papers, but we also wanted them to do longer form presentations. So what we did with the presentation exercise is we gave them two different scenarios. One was you've got a new client who really doesn't know the first thing about how to engage with a lawyer, how to hire a lawyer, and so it's really more of a marketing pitch. It's just, do it in Prezi or PowerPoint or whatever you choose to do, and walk your client through the process of how you're going to interact as their attorney. So that was one scenario. The other one was you're a litigator and you're going to go into court and try to convince the jury that this workman's comp case was the fault of the company, and some guy was moving a box in a warehouse and it fell on him and broke his leg or whatever. So I was hoping that a lot of people would choose that and do like cool little visuals in PowerPoint or do some kind of groovy animation using all the online animation tools. Not a single student chose that one. They all chose the kind of tried and trusted, here's a PowerPoint about my law firm and here's what I can do. That was just the way the chips fell. So it was interesting to see that nobody wanted to try to take it to the next level and do a short form presentation that was something that they would have had to use in court. And we did a whole module, which you'll see as I scroll through the syllabus. We did a whole couple of days talking about presentation skills and whether that was just general kind of presentation skills that you might have to be making in a boardroom kind of pitch versus litigation presentation skills. And we made the distinction between those two things because I think in a lot of senses they are different. And then again, we had that final paper which was due after the end of the classes. So there's the breakdown of how we chose to grade. 30% for the course project presentation, the actual presentation, 30% for the paper, 30% class exercises, and 10% for class participation. So again, let me blow this up a little bit. So here's how we kind of broke it down. Starting in early January, we did like a 20,000 foot overview, sort of a little bit of history of technology and law, and we did have them do a technology pre-assessment. It wasn't quite as formal as the Casey Flaherty Tech Audit or the Tutor Pro, some of the other tools that have gotten mentioned today, but it was helpful to us. We just put it up in Sakai, which is our learning management system. We used to be a Blackboard campus, now we use Sakai. So we just put up a little short form quiz asking students, what's your facility with Word, and what's your facility with different types of software? Have you ever used a case management solution? If so, which one? Was it Time Slips? Was it Clio? Was it Time Matters? Have you ever used a document management system? Are you familiar with these things? Do you know e-discovery? Have you ever used any e-discovery or litigation software tools? So we kind of just put a teaser questionnaire out there, and we told the students before the first day of class, actually, please complete it. And believe it or not, we had everybody do it except a couple students who did it there in class on the fly. And it was helpful for Steve and for me in engaging kind of, okay, who are we dealing with here? Because I think there's oftentimes this false assumption that, oh, we're dealing with millennials. They all know about computers, and they're all so much smarter than we are as far as this goes. And that's really not true. They know how to play on their phone, they know how to send texts to their friends, and they know apps and all that good stuff. But as far as their exposure to the kinds of technology that's really impacting the profession, not so much. And that's the whole point of the class. So it was a good sort of baseline that we were able to set, just with a simple tool there, simple quiz. So then the first week of class, we really dove right into all the ways in which lawyers communicate online, through mobile, instant messaging, texting, and things like that. But we really kind of focused on the ethical considerations. We took a pretty deep dive into the model rules and talked about client confidentiality, obligations that surround that, the obligations surrounding just being effective as a lawyer and all that good stuff. And this looks like you could spend a couple weeks on it just on January 12th there. So it was a lot to kind of get into, but we wanted to sort of set the tone that as we got into all these different types of technology, whether it was case management, cloud-based stuff, or whether it was e-discovery tools, we wanted to make the students aware early on that with technology comes risk, some degree of risk. And again, I think we assume that they just know this stuff, but you know, how often do you see a student sitting at a Starbucks working on a confidential document? It probably happens more often than we'd like to admit. And you know, if they're in the clinical program, for instance. And that's something when I do the training every year for our clinical students with Clio, they get all excited about the fact that it's cloud-based and they can access it anywhere, anytime. But I'm always quick to remind them that, you know, when you're in the clinic now, you are a student attorney. You're representing real people with real lives. And if you're sitting at the coffee shop and you get up to use the restroom and you've got some client's document up, that's just bad form. And it's funny because they don't always think about these things. They don't think that people can be sniffing Wi-Fi and hacking their password and all that good stuff. So we tried to really kind of, you know, put the fear of God in them in a way as far as their ethical obligations and as it relates to technology. And we cited the model rules and read, you know, the competency rule with the comment about lawyers should now have some knowledge or facility with technology, and that got added by the 2020 Commission just a couple of years ago. It was the first time it was actually mentioned in the model rules. In any case, so that's how we started off and kind of set the tone. And then we got into case management. And again, not to be a Clio shill, but because our clinic was already using it and because I was really familiar with it, we did go through those exercises that Maureen cited. And they are really cool. They're just simple 2 to 3 page. There's one that's a litigation exercise, one that's a real estate, so a more transactional type of law exercise. And it's kind of a soup to nuts, get your feet wet thing. You set up a contact record, you set up a matter record, you set up some related contacts within the matter record. And the students, in the span of an hour, really got a sense for what it was like to create a case. And we had more positive feedback about that one day, or at the end of the year when we got the course evals, we had a lot of positive feedback about the day that we required everyone to bring in their laptops and walk through this Clio exercise. Because again, I think there's this hunger among the students to have these sort of hands-on experiences and not just be lectured to every day, every other day for 45 minutes. So moving through the syllabus here. Then we did the section on presentation technology. Steve, and this is another thing just procedurally, we talked to some friends in the law library who had co-taught ALR, Advanced Legal Research, and we said, how do you guys divide it up? Do you sort of co-teach every class, or do you take one day, Donna, and then Sarah, you take another day? And ultimately, Steve and I tried to do it more the latter form. So he would teach the Monday class, I would teach Wednesday, or if he was going to be out of town, vice versa. So it was kind of a tag team thing, but just for you know, supporting each other, we always both showed up in class. We always tried to show up, and I would sit off to the side, or Steve would sit off to the side, and that's the way that we rolled. I think the students appreciated that because they didn't get bored of looking at me or listening to Steve or vice versa. He did a whole class on PowerPoint and effective use of that, and then I did Prezi and did some other stuff. And so we tried to mix it up in that way. I should also mention that we were lucky enough to teach the class, which was 15 students. I don't think I mentioned it was a smaller seminar class, but we did have a full registration. We taught it in our brand new courtroom, which was a lot of fun because we just did a huge renovation of it last summer, and not anybody else had used it for an elective course to that date. And we thought, well, what better way to sort of model the technology that we have? And we knew we were going to be doing a segment on courtroom technology and, you know, presentation skills. So that was cool to be in that courtroom setting. The students were sitting in the gallery. You know, we spun the podium around as if it were in a courtroom setting. And so that's how we demoed things in that week. And that was actually the next week that we did after presentation, so it kind of flowed into, you know, how would you present in front of a jury? What are some of the things you need to keep in mind? Planning for the power to go out. Always something good to remind the students. Always have a backup. My flight got really badly delayed and I missed the keynote, but my friend was telling me earlier that the poor keynote guy on opening morning had some sort of a laptop crash, I understand. So my heart goes out to him because I know how nerve-wracking that can be. But you know, we tried to impress upon the students that even if you have facility with technology, always have a plan B. show up with a jump drive or flash drive, whatever you want to call it. If you have a laptop, make sure you bring the little adapter to court. Call the clerk of court ahead of time. We even had a student who said to us, it's so easy to go out and test your stuff ahead of time. And I said, really, that's interesting. And he said, yeah, if you call the Durham County Court or the Orange County, the surrounding counties by Chapel Hill, he said they always welcome people coming in ahead of time, even though we're law students, and sort of testing things out if we're going to be participating in a case. So that's kind of good give and take information and exchanges that we would have with students sometimes who had gone out and done work during externships or internships and so forth. So what's next? Knowledge management, large complex case management. This is where we got into the DMSs, document management systems, data mining, big data. That's another term that you start hearing thrown around a lot lately, and I think a lot of people don't have a full grasp on what that means, but we talked about how the social media companies are mining huge amounts of data, and increasingly some of these litigious cases involve huge volumes of data that have to be managed, and how do people go about doing that? That led us, in turn, directly into the e-discovery piece. And I know, again, there was some discussion about you guys are a little bit farther away from Atlanta, so it's hard to get people to come and speak. Well, I'll mention one company again. I don't mean this to sound like a plug, but CALIcon is an e-discovery vendor based in Chicago. They have a product called Relativity, which is pretty big in AmLaw 100. They've got a pretty good piece of the market niche. And they, like Clio, have a really robust academic outreach program. And they told me, oh, if you're going to do e-discovery, or even if it's not a whole class in e-discovery, we'd be more than happy to send down a guest speaker at our expense, fly somebody down who is a former attorney and now is one of our sales folks to talk about the ERDM, the electronic reference discovery model, and he'll walk you through all the steps of e-discovery. And I thought, wow, how can I say no to this? And I said, what's the catch? Do we have to sign some sort of software agreement, or do we have to later buy your product? And they said, no, not at all. So they did that. They flew this guy down. He's a great guy named Stan Lewis, and he came in and gave one of the guest lectures that we had. And the students really, I think, along with the Clio exercise, again, they really latched on to that and appreciated that they were hearing from somebody who had been out in practice, who had used some of these tools, and they got to see it with their own eyes. Now, unfortunately, one of the cool things that we didn't get to do is CALIcon even goes to the length of setting up a sample database for you. And so if you want your students to go through and actually learn some of the document review and process within the software, they give you a demo instance. But it took us so long to sign the doggone contract, even though we weren't going to pay for it. We did have to sign a terms of service agreement. And our legal university counsel had to get involved. And once the ink was dry on that, it was already about the first week of class. And so they didn't get a chance to set up this dummy instance of Relativity with sample data, but they will do that for you if you coordinate with them and if you develop a relationship with them. And I've actually since then gone to Relativity admin training up at a law firm in New York. I used some of my own professional development money to go up there in May and sort of learn the software myself, because what CALIcon wants is if you are going to be doing a deeper dive and using Relativity in an academic setting, they want at least somebody, a reference librarian or somebody else, to have gone through that admin training. Yeah?
How do you prevent the guest speakers from turning into a sales pitch?
Really good question. And I was guarded against that, and so I picked up this guy from the airport when he came in that day, and I told him the sensitivity around that. I mean, I was pretty straightforward. I said, as a big state school, we have to be cognizant of that and be cautious about seeming to endorse any given product. And I've had to walk that same fine line with Clio. That's why I joke with Gary about, don't always make me the Clio guy because I'm going to get fired. But no, but seriously, I said to Stan, I said, we're so glad you're here. We're very appreciative that CALIcon took the time and money to send you here, but please don't make this a 1 hour long sales pitch. And he really walked that line well. I mean, he talked about the broader, EDRM and just the skills that would affect you in any sort of e-discovery software, and he didn't give a hard sell. So I don't know if everybody's experience would be that way or if he always gets sent. I don't think he's the only guest speaker that they have, but it was like a soft pitch. So that was a good successful part of the syllabus. Then we got into, yeah?
On the same topic, could you accomplish the same thing if you just did that presentation remotely? You know, Skyped in or GoToMeeting or something like that?
I think so, and as we get down farther toward the bottom of this page, we actually did that later on. We brought in Richard Granite, who's got a long history of talking about technology, the intersection of technology and legal education and lawyering. He came in via web conferencing one day later on when we talked about virtual lawyering. We had asked his colleague Stephanie Kimbrough, who was unavailable, and then we asked Richard, who I'd met at the CLIO conference a couple years prior, and he was gracious enough to devote an hour of his time to us. And so, yeah, we wanted to model some of the technology that lawyers are using, and so we thought, well, let's have one live in person, since Kay Cura was willing to send him, and then let's do one virtually, because I think that's a good modeling of the technology that some of these lawyers are going to be using. I mean, just as anecdotally as a side note, in the past couple of years, our career development office has seen a huge uptick in the number of law firms that are hiring remotely. There's a couple big law firms in the Raleigh-Durham, Chapel Hill area now that are no longer doing on-campus interviews. They're no longer participating in the OCI program at the law school. And more, we have a little dedicated video conferencing room in the career development suite. And we've got an older model CALIcon, nothing terribly fancy, but more often than not, they don't even want to do the CALIcon, they just do Skype. And we even had one student get a clerkship with the judge through FaceTime. The judge was in his chambers. He said, if the student can do FaceTime, that's what I prefer. And the student said, sure, I got it on my phone. I mean, I'll call this judge and do an interview. And the guy got the job. And that was like 2 years ago. So that's when you start to see this, the shift in the way people are going about doing things. So, yeah, so you see what else we covered. Then we went into, PACER and some of the electronic filing and things like that, online court-related services. And we had the guest speaker on virtual lawyering. And then the last page of the syllabus here, I think we were pretty much at that point did, mobile apps and lawyering. And again there, we collaborated with one of our reference librarians, great guy Tim Galena, came in, and he's just real into apps, and he wanted to help talk about mobile apps. And so he just covered a broad spectrum of the many different types of legal apps that are available. And again, it gave the students a break from hearing from the same two talking heads. And Tim was very engaging, and the students were able to download some apps. We originally were going to do on March 23rd that thing where it says laptop and mobile device security considerations. It was meant to be sort of a lab day where students would bring in their mobile devices, they would bring in their laptops, and we would show them how to make sure you got a passcode or a little password or do your thumbprint or whatever for the iPhone, and definitely secure your Android device or your Windows phone. Because again, I think people take for granted that they don't need to do that as a student. But the minute they're representing clients, again, we wanted to make them aware of those ethical considerations. We didn't have time to do it, unfortunately, so that was one of the points on the syllabus where we fell a little short. We just ran out of time, so we weren't able to do that. I'm going to draw your attention out of that last big section there, the final project presentations. You'll notice that there are quite a few days devoted to that. We only had 15 students, but we wanted to give each one of them about 20 to 30 minutes to talk through their final papers, which of course the ones that drew the short straw needed to be finished with their papers by March 25th because that was the first day that we had them start the presentations. That took up like the last 3 weeks of class. That was our biggest mistake. And I say that not because of the quality of the student presentations. We learned a lot. I mean, I learned a lot as their instructor, and I think the other students learned a lot. But I think the students kind of felt like, hey, I'm paying money for you guys to teach me, not to watch my student peers give presentations. So when we redo this, and again, lessons learned, when we talk about what worked and what didn't, that was one thing that we want to rethink that a little bit. We want to maybe, we definitely still, I think we'll want them to do a longer form research paper, but shorten the amount of time spent in class to do the presentations. Maybe table the presentation and just make it a paper, and focus more on having them do a PowerPoint or do a short Prezi, maybe make some of them do a litigation scenario presentation rather than have them all just do like a marketing pitch PowerPoint deck, those types of things. So these were some of the lessons, you know, it's like learning to fly. You kind of have to, hopefully once you do get behind the wheel of the airplane, you know how to fly. But in this case, we were kind of, you know, this was the first time we taught it, and we were learning as we went in some instances. So e-discovery, more e-discovery. I forget who it was earlier in the day said some of this stuff doesn't apply to all types of law practice, but that was one of the modules, if you will, that I felt like we really sold a little short. There's so much to cover, and it really does touch so many areas of law now that, and with this resource, with this access to this one particular platform, again, sort of letting people know this isn't the only game in town. There are other solutions out there for e-discovery, but since we had access to that resource, I wish we could have given the students a little bit more hands-on time. And again, had we set up this agreement with CALIcon earlier in the semester, we would have had a demo instance of relativity. People could have dived in a little bit more. So that was another sort of lesson learned. The case management thing I mentioned, that really, in the student evaluations and the feedback that we got at the end of the year, that really kind of came back positive, and so I think that was a good thing. And then the mobile lawyering and virtual lawyering, that day people seemed really excited about all these apps because there's more out there than there are more out there than they were aware of. And you know, Tim gave a nice overview of both research mobile apps and then productivity apps. We kind of divided it up in that sense. And so, you know, here's ways that as a lawyer you could look up a statute very quickly on the fly or do some research on the go. Fastcase is a great example. They're really a great mobile app as far as research goes. And then here are some productivity apps like back office kind of stuff. You know, Clio's mobile app is awesome. They develop it for both iPhone and Android. And I've always had an interest. I got an information science master's degree, and I have an interest in UX and UI, you know, user interface and user experience. And I see so many potentially really cool apps that fall short in that UI level. They do a lot of stuff, but getting to it is difficult. And again, I'm already a Clio fan, but when they made the big splashy announcement about their mobile app a couple years ago, I was really impressed with the way that they had designed it, and they've continued to refine and make improvements. So those were sort of the things that stood out, those three big topical areas. And I think because we spent too much time on the student presentations and not enough on other things, those were some of the things that we're going to do next time around. So, you know, less talk, less lecturing at them, more interaction. We had a hard time generating student discussion. We would assign readings. We did some case law that had good examples of e-discovery or good examples of ethical violations surrounding use of social media. So we tried to go to case law, and that was a good learning experience for me because, again, I'm not a lawyer. I don't even play one on TV. And you know, so I kept saying to the students, look, I've never practiced law. I'm coming at this from the technology angle. Steve's got a JD. He never practiced either, but he's, you know, got that credential at least. So we would tag team on that stuff. But I think they would do the readings, but since it was a 2-credit elective and it was so much less pressure than all their other classes in a lot of ways, I think a lot of days they just kind of showed up. They listened well. They participated to a point. But I wish that I could have generated more sort of collaborative effort, and I think breaking the teams or breaking smaller groups of students maybe into small firms, you could do that within Clio or some other platform, is a really good idea and would generate more of that interaction. I've already talked about sort of narrowing the scope and doing a deeper dive on fewer topics. Again, we were kind of like throwing everything at the wall to see what would stick, and I think that was an okay approach this time. And we felt okay about doing it because we had floated the course proposal up to our academic affairs committee and they had approved it, so we didn't think we were going outside the bounds or trying to be too broad. But having taught it now once, I definitely think narrowing it and going a little deeper would be great. I already talked about, you know, less time on the student presentations. I'll also say, just personally for me, it was a huge amount of work above and beyond my day job, which is the assistant dean of IT, running the IT department, managing big infrastructure projects, managing our web development, you know, overseeing end user support and liaising with our instructional technologist. And And I try not to be a micromanager. I've got a great team of people. I'm blessed with great folks who I've had for a number of years. I haven't had much turnover. And they were very forgiving of the boss man being off doing preparation for class a lot of the time. And because it really made me appreciate what professors do, I got to say, more than I already did. I mean, I already have a great deal of respect for our faculty and what they do on a week-to-week basis. And you think that a lot of them, maybe after teaching crim law for years, maybe are on autopilot. But there's something nerve-wracking about going into a room where a bunch of students have paid money to get educated and wanting to do a good job. I mean, I took it very seriously in wanting to do it well. And so the amount of time that I spent getting course outlines ready the night before or the week before, making sure that I was going to be able to cover 55 minutes and that it wasn't going to be like a Cali presentation where if I ended 15 minutes early, we could all go out and have beer. You know, it was a 1 o'clock class. It was right after lunch. And we often had that post-lunch effect of people in the back row, you know, nodding off. So I wanted it to be lively and engaging, and I really strived to make it so. But I will say that it was a considerable amount of work on top of the role that I already had. Also, incidentally, just another procedural note, I'm not embarrassed to admit that when the time came for me to actually be able to teach the course and for them to be able to pay me as an adjunct, I needed an adjunct appointment. I didn't have one, unlike Steve from the law library, who I co-taught with. And so there was a little bit of uncomfortableness when it came time to give me my adjunct appointment because I don't have a JD. And the law faculty were like, we're not going to give you an adjunct appointment, Doug, because you don't have a law degree. And so I actually got my adjunct appointment through the School of Information and Library Science, where I'd earned my master's. And the dean over there actually had been my thesis advisor several years ago. So it all worked out, and I didn't take it, I didn't take it personally. I mean, I understand. They didn't feel like I had the level of credential for the law school to make me an adjunct instructor. No harm, no foul. That's fine. I got to teach it. I was just thrilled that as an administrative staff member, they allowed me to do it. And I'm really excited about the opportunity to do it again in the future. The sad note is that, you know how for 3 years they didn't add it to the academic calendar and then they finally added it? Are we on it next year? No. Yeah. So I was all psyched. We taught it. The students gave us great course evals, and I talked to my friend Jeff Hirsch, our Associate Dean for Academic Affairs, who's a big supporter. He's the one who finally got it added. And I said, Jeff, what gives? What happened? He said, there's just so many elective courses that we don't even teach every year. And you know, these are being taught by either tenured faculty or in a lot of cases adjuncts, practitioners who are alums of ours. And I totally understood. After I talked to him about it, I was a lot less hurt. But the other complication came into play in the fact that Steve, my colleague, is retiring at the end of the year. And there's a state rule that says if somebody retires, they can't come back 2 weeks later and teach as an adjunct. They have to wait 6 months. So even if they had put it on in the spring of 2016, I probably would have been flying solo or teaching it with somebody else, which would be even more work. So yeah, we're not on next year's calendar. I hope to be teaching it again, but I appreciate all your time and attention. And if anybody has any questions, we've got a few more minutes, and I'm happy to stick around afterwards. So yeah.
It sounds like the things that you used are Clio and other software. Everything was free, and it sounds like it was either cloud-based or something that students could download on their computers. I'm wondering if there was anything that you wished you could have taught them about, but it was cost prohibitive, you needed to purchase licenses, something along those lines.
I don't want to be too quick and glib in my answer, but no, I really don't think so. I mean, that's the nice thing is we did a whole section on A to J author as well, and talked about integrating with hot docs and how we as law students or they as law students had access to that. CLIO, the Academic Access Program, this K-Cure Relativity Outreach Program. So I don't think there was anything that we said, gosh, I wish we would have had a few more dollars to put towards it. And that's why I think this is encouraging for everybody.
The one program I would say, I can't work for anybody, the one program we did where that would apply is I would like to teach Adobe PDF redaction and base numbering And even on a student, I mean, it's about, I think, somewhere around $12 to $15 a month for the current CC license, and I didn't want to even have a student have to pay.
Yeah. We got asked about that, and they do some of that in the clinic. They have that. We give them access to Adobe Acrobat Pro through Citrix, but yeah.
We actually, one of my library faculty is teaching a course in the fall where he wanted to do the same thing. So what we did is he only had a small interest in it for the students. So in one of our labs, we just went ahead and purchased the pro licenses to put in our lab, and he'll teach the class in the lab.
Yeah.
And that's just one part of the class. I don't even know exactly what class it is. I was just involved in obtaining the licenses.
Yeah.
And also a lot, in the previous session that was in here and it's here, a lot of those technical skills, at least with our institution, we have faculty that are more tech savvy, or we have adjuncts that are coming in and they have a case management, small practice, where they cover a lot of this, and they'll get Clio or some other free software, they'll load that on the lab, or the students can put that on their machine.
Yeah.
They go over the ethics portion, they'll do the apps. We've had another adjunct teach something specifically about e-discovery, visiting professor, short-term course. In our legal research class, same professor who's doing the Adobe redaction stuff, goes over the free online searches, the apps for that. So at least in our case, most of what I see, the content of this course is actually spread into the classes where the students are already going to be taking those. So it's not as much of a competition with those same boutique classes because it's not separating out the tech from the law.
Yeah.
Now, where we fall short and what I would like to do is a lot of the basic computing skills, and let us help you, make a table of contents in less than 3 hours.
Yeah.
That kind of thing. And we haven't made much progress on that, so we don't have enough content really for a 1 credit hour course.
Yeah.
It's more of an undergraduate thing, so I guess I realize we're lucky that my faculty is already doing a lot of this stuff in the individual courses.
Before I forget, I promised you there'd be a raffle prize to anybody. There's my email address. We had 4 song titles. Don't shout them out because you got to email me. And the first email that I receive that has all of them right will get a free copy of the Stars Explode CD. That's me. In my spare time, I'm a rock and roll guy. So I didn't know what else to bring. So yeah, 10-song CD. So we had One Way or Another, Welcome to the Working Week, Learning to Fly, and Changes. So again, don't shout them out, but if you send me an email, whoever's hits my inbox first.
2 out of 4 unless I take advantage of the
But learning to fly can be...
Learning to Fly could be two different people, and if you get them both right, then I'll give you a big hug.
I don't think I get the second one, but I know the third.
Yeah, Maureen, one last question. Well, North Carolina bar members get access to it, yeah, so our students can...
Yeah, because I've been lucky to both Cascades and Clio about showing the integration.
Yeah, that's a good piece. So, well, thank you, everybody.